So there I was, the middle of the night. It was literally 2:15 in the morning, flipping through papers, trying to read all the white papers and research papers the defense dumped on me the night before. And I kept going back to my notes over and over and over again. And I took the deposition the next day, and I remember thinking, we need more resources for these types of cases. I run into the same problems over and over again. And I know this because I talk to 5 to 7 to 10 lawyers a week about their TBI cases. And I decided I wanted to publish my notes, the things that I felt gave me that advantage on every TBI case I ever worked on, because I took notes on everything I ever did on all my cases. And I started organizing them, I started putting them together, and pretty soon it got longer and longer and longer. And then pretty soon I was like, I can publish a book on this. And I think I can systematically help lawyers across the country with the problems that they're facing with TBI cases. My name's Taylor Ernst, 2024 California Lawyer Attorney of the Year. I've gotten a $63 million verdict and wrote The Ernst Way. Spoken to 25,000 lawyers and doctors in almost every state in the United States, and we helped 250 lawyers last year on their TBI cases, not including our own cases. TBI lawyers call brain injury cases the invisible injury. They call it that because they think the jury can't see the injury, but I think more than that. It's the lawyers themselves that are using the Orthopedic Playbook on TBI cases and leaving money on the table. I can show you why. I was a couple weeks out from trial a couple years ago, and the client was sitting in my office, and I'm getting ready for trial, and we've done all the experts, and he looks at me and he's like, yeah. I'm like, can you meet tomorrow? And he's like, I can't meet tomorrow. I got an eye appointment. I said, what do you mean eye appointment? He's like, well, I've had eye problems since this incident. I said, what do you mean? He's like, oh yeah, I got double detached retinas. I'm like, what? And he's like, yeah, my eyes haven't been right since the incident. I said, why have you never told me about this before? This has been a TBI case from the beginning. And he said, I didn't think my eyes were related to my brain. And I remember the revelation I had. I was like, oh my gosh, like if this happens to me and I'm looking for it, how many cases does this happen to other lawyers when they aren't looking for it? And that's the reason I think it's the invisible injury. Is juries see the client and don't understand the injury, but so do lawyers. We miss it. And because we miss it, we are undervaluing our cases systematically. And until you have a system put in place to directly address how to make sure you get every possible symptom that your client has, you are getting lowballed. The cases are not worth what you think they are because you are not getting and gathering all the things you really need to be able to value your TBI case correctly. And lawyers ask me, they say, well, how do you value TBI cases? And I'll say, tell me about your client's symptoms. And I say, well, does your client have dizziness? Do they have problems with their balance? Do they have problems with their emotional outbursts with their friends? Well, you know, the usual TBI symptoms. And I tell them, if you can't specifically tell me what the symptoms are of your client, you don't know the case well enough. And if you don't know the case well enough, how can the defense possibly know the case well enough to value it correctly? And so when I get off stage at places like TBI Med Legal and the lawyer walks up to me and says, I hired the TBI expert, what do I do next? The defense lowballed me. I realize they're asking me a question here when if they really want the value of their case, they need to get here. And there's a lot of work in between the two. That's what I want to address. That's why I think they're called the invisible injury, is because just like we assume that the juries don't get it, lawyers, we need to do more. We need to step up and really take inventory of all the symptoms your client has. Then you take those symptoms and using resources that we're providing, you translate those symptoms into the objective tests and into the day-to-day findings that are messing up their life. That's how you get the value you need. It's not an invisible injury because it's small. Lawyers think it's about juries seeing the client and seeing them look okay. I think it's invisible because lawyers miss things that aren't in the medical records. If it's not in the medical records, to lawyers, it doesn't exist. They're relying on a brain-injured client to tell them about their own injuries when they have memory problems, they have problems understanding their deficiencies, and you're relying on someone who's inherently got brain compromise to tell you the truth about their own injuries. And it's the reason that when you talk to their spouse or talk to their friend or talk to their boss at work, they go, they're a completely different person. And the lawyer seems surprised by this. It's because the invisible injury was literally invisible to the lawyer. The lawyer got fooled as much as the jury did. And that's what we need to step away from. We need to go beyond the medical records, find the truth in day-to-day life. That's where you find this invisible injury and figure out how to make it visible, not to just the jury, but to the lawyers and the defense lawyers as well. Yeah, I got a call from a lawyer one time who said, it's not that significant of a TBI case. It's a mild TBI, and I worked it up, and the offer from the defense isn't that significant. What do I do? And I remember talking to him and asking him a couple of questions. And you can have mild traumatic brain injury cases that are catastrophic, lifelong consequences. And because you get the invisible injury where the lawyer doesn't know what to ask about, mixed with the mild word in front of brain injury, they don't realize that that person is probably going to need care for the rest of their life. Couldn't remember their friends and family's names. If they walk more than 2 blocks away from their own house, they get lost. There were sticky notes on everything they did all day long, and they had something like 20 alarms on their phone going off because they literally didn't have executive functioning with memory that allowed them to operate in normal day-to-day life. If they didn't have the spouse and family support around them, they quite literally would end up homeless. Give you an example of how serious this is. As the book talks about, more than 50% of homeless people actually have had a mild traumatic brain injury or worse that impairs their ability to deal with day-to-day life. That's the fight we're having, and that's the reason that we need to step this game up. The most common thing lawyers say to me about their invisible TBI case is they'll say the MRI is negative. And I will look at the MRI and it'll be on a 1.5T MRI, meaning it's not the high gold standard MRI and it generally doesn't find everything. So if they have an MRI and it comes back clean, the lawyer thinks because there's no visible injury, like an orthopedic case or a broken bone or something like that, there's no injury. And that couldn't be further from the truth. The MRI only shows some brain injuries, and it only shows some brain injuries when they're the injury that MRIs pick up. If it's diffuse axonal injury, a lot of times if there's no DTI, it doesn't show up on the MRI at all. And so when a lawyer asks me questions that says, oh, there's a clean scan, that doesn't mean what I think they understand it to mean. When a lawyer evaluates a case in the same way they'd evaluate a normal injury case, they look at the medical records and they interview the client. They don't understand where all the pieces of evidence are. There's pieces of evidence at the client's work. There's pieces of evidence about how they're interacting with their friends, their family, their garbage man, their laundry woman, like the things they do in day-to-day life. There's evidence everywhere they go with everything they do. And if you just read the medical records like ER visits were never designed to disclose cognitive decline. They want to know, are you going to die in the ER? And if not, if you don't have a brain bleed that needs emergency brain surgery, they're not going to treat the brain injury part of it. They're going to let a neurologist deal with it when the cognitive decline is showing up weeks later. Injuries hide themselves because people don't want to say they're broken. Inherently, when someone has a brain injury, they want to be back to baseline. They want to be normal. They know something's wrong in their day-to-day life, and they want to think it's a short period of time they're going to overcome through sheer effort and get better. And when clients tell us about their brain injury case, I had an example years ago where the client came into our office and said, I just want to get my car fixed. The insurance is messing me around on getting my car fixed. And we said, what happened to your car? They're like, it rolled 4 times on the freeway going 70 and I got ejected. And we're like, how? What? And they're like, oh yeah, I got banged up and I've had memory issues. And the ER said I didn't have a brain bleed, so I don't have a TBI, I'm fine. And that happens again and again. And unless the lawyer's willing to say, well, tell me how your home life's going and how's work been, or have you been able to go back to work? All of a sudden they're like, yeah, I have had all these problems with all those things. But are you sure it's related? Doctor office said I didn't have a brain bleed. They think brain bleed equals TBI. And if no brain bleed, no TBI. And they're not the same thing. And if lawyers can't tell them that, it's a problem. The defense has a file you've never seen on your client. And most people, when they hear that, inherently think it's the client's medical file. It's not that. I'm going to tell you why. When I say they have a file on your client, everyone inherently thinks it's about the TBI, but it's not. We prepare our medical case. The defense is preparing the human case. That's why they do sub rosa. That's why they get the social media. That's why they gather all of this information about your client, is because they're aiming it at the human case. They know someone who has a picture that they convince the judge is relevant that makes them look like not a great person or in a light that isn't as good, the jury inherently doesn't want to give them as much money that they need for their brain injury. Let me give you an example of this. I can remember the first time when I was a baby lawyer, I was sitting in a deposition. It was a very senior trial lawyer. I remember he asked 3 questions and I remember being like, oh my God, this guy's a trial guy, because they were so clean. They were so on point. There wasn't a compound thing in them. They were all triable, usable, simple questions. And after about 20 minutes, I realized it was a whole different case than what I knew about. And it was because I hadn't prepared the way I should have. I prepared the medical side of the case. But when the defense lawyer took a picture out of this folder, and he takes the folder and he opens it slow, grabs the big picture and pushes it across the table. This was back before COVID happened. And the client's looking at it and he's like, is this the wine that you like to drink and you were drinking on the day of the incident? And she's like, yeah. And I'm looking over her shoulder trying to see what it is. And I get a picture and I get it in front of me and it's this gigantic wine jug. And it shouldn't matter if she was drinking before her TBI, but it does. And the fact that the wine wasn't a little wine thing, it was a giant jug of wine, it influenced me and I was the lawyer. And it's that kind of stuff that the defense inherently has a file on all the clients you are working on. You need to know that. And they have information from Facebook, from social media, from sometimes friends and family, if there's a split in the family, from divorce records. They have all this stuff. And if you just work the medical case and don't understand what the defense file actually looks like, you're litigating the wrong case because the defense has a file that you know nothing about. One of the advantages to TBI cases is you need to know the human story better than the defense. To give you an example of that, one of our last trials, the client had biked numerous times over and over again before the trial came up. And the defense saw that as he can't have a brain injury and bike. We saw that as that wasn't the part of the brain that was damaged. His memory was damaged. His balance, he didn't have an issue with that. And as long as you have the story understood better than the defense, you're presenting the human story. You don't want to start behind on the human story. And it's the way that we figure out how to systematize exactly the setup for the trials that is something that you want to know how to do. You know what the diagnosis is in the medical records. You know what the deposition says. But when the defense has more human stories about your client than you do, you know the medical, they know your client. They have an edge on you. You don't want that. You want to have the information advantage about what you know of your client. You want to know more about your client and disclose all that to the defense. But you want to know so much more that when you tell a story, the jury inherently goes, that makes sense. That sounds like someone that needs our help. You win that human story, you're going to win the trial. Give you another example. And it comes from knowing the human story of your client. As we had a client one time, we're getting ready for trial, and the defense whipped out a document in expert disclosure and put in their opening statement saying, this is a client who has, they disputed the brain injury, an alleged brain injury that dealt contraband to prisoners. And I remember first hearing about that fact and being like, oh my goodness, I didn't know about it. It blindsided me. I finished that expert depo, immediately went to the client's house and sat down with him and said, what's the deal? Like, what happened? And the client was like, oh, yeah, all the other prison guards were mad because, I'd share cigarettes with some of the prison people and they'd have less fights and less people would get hurt and there'd be less problems in the yard. And I ran my thing way better and all the other guards were mad at me. And so, yeah, I definitely, if they say contraband, sure, but it was cigarettes and it was no big deal. And I remember being like, that's not so bad. It settled in the case when the defense paid our demand. But the thing that really was the core story was the fact that once I knew the entire human story, it wasn't a problem. If the defense had just told what they knew of the story and it was just the defense version of it, and I didn't have the entire story to come back and explain why my client was that good individual that was productive, helpful member of society, I would have been blindsided in a way I couldn't fix, and I probably would have lost the trial. When the defense pulls out a document that you've not seen before, fundamentally, it means you didn't do your homework. Because if your client knows what it is and you don't, it means that you haven't spent enough time with your client, period. And every time this happens to me, I get the fear of adrenaline. I don't know what's coming next. I wonder if my case is destroyed. It happened to me until we started putting the systems in place that I talk about in the book. And the way we dealt with it was we need to know everything about our client, anything related to who they are as a person, how their day-to-day life is affected, how their brain injury has affected everything that they do, what is affected and what's not affected. And until you start understanding all those aspects of your client, you're going to get blindsided at Depo. And people always want to say, oh, it wasn't your fault. Frankly, if you get blindsided at Depo, it is your fault. Something that happens with plaintiff lawyers is the defense gets a record that the plaintiff lawyers don't have. It generally happens in the following scenario, where your client will have an injury in, let's say, 2024, and they will subpoena all the records from the ER, and the ER will have a bunch of comments about their previous history from 2014, and the plaintiff lawyer thinks, oh, that's 10 years ago, and doesn't get any of those records. And the defense subpoenas every record they find related to anything. Plaintiff lawyer doesn't order copies of the subpoenaed records, and then the defense has something the plaintiff lawyer doesn't have. It's a way to set yourself up to have a problem at Depo. Let me give you an example of a case where the defense knew more about the client than the plaintiff lawyer did. And I remember coming in and the lawyer wanted us to consult on the case, and we were just trying to figure out how to structure their TBI case for trial. Last year, we consulted on almost 250 cases for other law firms across the country. And the lawyer was having me talk with his client under attorney-client privilege. And the client said 3 things that all significantly harmed the case that the lawyer wasn't aware of any one of them. Any one of them was a issue that if you caught it early and dealt with it and framed the case right, wouldn't be a problem. But if the defense stand up in opening and blindsided you with it, you wouldn't have done a good job for your client. Let me give you an example of the worst ambush I'd seen of another plaintiff's lawyer. And this was, we were reviewing the video footage of another law firm that wanted to bring us in to try a significant TBI case. I mean, 7 figures, maybe 8 figures. And it was such a simple answer in the deposition that I remember looking at it and being like, why? Why did they do this? And it was something so simple as the defense asked, have you ever had any back problems before? In a TBI case, it wasn't even a back problem case, said, no, I haven't. And the defense lawyer pulled out 3 different sets of records, a back surgery and 2 prior ER visits from 7 years before the incident happened, and made the plaintiff look like an idiot and somebody who lies. And you take a credibility hit like that, it affects everything you do in your case, because if it isn't clear, it's something I talk about in the book quite a lot. Almost everything we do in TBI cases, because of the invisible injury, it's a credibility fight. It's a race for who can be the most credible, the fastest to the jury. And you build up credibility and you build up credibility and you build up credibility. And then at the end, when you're giving closing, that's when you can say, hey, I didn't have any trust from you at the beginning of this trial. You shouldn't have trusted me. I'm a lawyer coming in asking for money for my brain injured client. You don't know me. You don't know my client. But at the end, look at all the credibility I've built. I've given it to you straight the entire time. Now I can tell you what I think the case is worth and what I think you need to do to bring the justice home. Social media is something that the clients will just do their day-to-day life. In the last trial that we had that we got a mid-7-figure verdict, one of the big issues that we ran into was the client's social media of him getting married, him going on vacation, and him just doing daily life. The defense shows pictures of that and they don't put it in context. And so the defense sees what's happening and they show the jury and say, look, he got married. And they try and infer that because he got married, he doesn't have a brain injury. When the real truth is, they don't know what that was the next day or how different the vacation was, or she married him because she loved him dearly. When I was a younger lawyer, I didn't understand how to work up TBI cases, and so I worked them up like any case. I'd say, I'm working up the case. And I didn't have a plan for working up a TBI case. I didn't have a plan for working up a chronic pain case. I didn't have a plan for working up a wrongful death case. They were all just quote unquote, work up the case. And I remember the first time I saw a defense lawyer have a very specific plan. I was a very young lawyer, and they had a very specific plan of exactly how to deal with something. And I remember being like, I should do that. I need to outwork the defense on every case I'm working on. And then once you niche down and you consistently are doing one type of case, like we're doing with TBI cases, you have the whole playbook. You know all the plans the defense could even possibly run, and you just rule them out one by one by one. And it's one, give me an example. It's funny to see a defense neuropsychologist and a defense neurologist that a lot of times they don't talk. And so you cross-examine the neurologist and say, you're going to rule out this, this, and this. And we talk about it in the book, and the neurologist says, yes, I'm ruling out those three. And then the neuropsych stands up and says, it's this. And you go, are you aware the neurologist ruled that out? And they're like, no. And it's the defense lawyers blowing up their own case because you're systematically approaching the case with more work and knowing the case better than the defense does. You're setting yourself up for massive success. I was reviewing a case for a lawyer about 3 months ago, and there were numerous depositions, multiple rounds of discovery. If I had to ballpark how many hours it had been hundreds and hundreds of hours on this single case. And I remember talking to the lawyer, and his entire focus was on a specific subset of what he thought the medical was important to the case. And partway through the consultation, I remember just looking at him and being like, I don't think you're focused on the right part of the case. And he said, what do you mean? I said, you're working on this and you've spent all your effort, all your time. You're working 80 hours a week on this problem. And I don't think the defense cares about that problem. I think the reason that they're lowballing you and giving you the low 7-figure offer they're giving you is because they have a problem with this. And I can remember, we were on a Zoom, and I can remember him looking at me and almost slack-jawed and him being like, oh. And I was like, it doesn't matter how hard you work if you're working on the wrong problem. You can spend 1,000 hours, and if you're working on the wrong problem that doesn't solve the medical thing that the defense needs to understand, you're not actually working hard. You're busy, but you're not moving the needle. And so if you understand the frameworks that we're teaching in the book, one of the core concepts we really want to focus on is you want leverage. And leverage comes from working on the most fundamental problem that is broken in your case. And in TBI cases, a lot of times, sometimes it's the medical records, but more often it's the human stories that underlie the medical records. And as I talk about in the book, one of the concepts is when you have a giant list in a neurology consult that says dizziness, aphasia, issues with headaches, each one of those symptoms is a story that has not been told yet. As I talk about it, symptoms are signposts. When it has a symptom, it's a series of a reoccurring problem that's interrupting their day-to-day life that you don't know enough about. And so if it says dizziness, people will talk about it as, oh, my client has dizziness. I'm like, well, what kind? Is it that they have to put grab bars in 7 places throughout their house? Or is it the kind that we had a client that had a chair that he'd get in, that he actually had the local school build a metal bars on both sides of his chair so that he could grab the metal bars and stand up out of his chair, and then he'd hang on to the metal bars for 5 or 10 seconds to get steady on his feet so he wouldn't fall over. What one are we talking about? And do you see how those stories are so different? And you don't get those stories by reading the medical records and then asking your own expert to read the medical records you already read and tell the same thing that he just writes, dizziness. You are leaving the fundamental human story that makes the case significant in a way that isn't allowing the value for settlement to be done correctly, which is also significantly increasing the risk that you try the case, and the case you present to the jury isn't strong enough. It reminds me of a story that a friend of mine who was in the military special forces told me, that he one time, there was this big race to get to the top of one of the mountains, and he got to the top, and it turned out that instead of winning, he'd actually gotten to the top of the wrong mountain. And it wasn't the lack of effort. He worked so hard to go achieve the thing he achieved, but he just achieved something that didn't matter. And it reminds me of the same way that lawyers approach some of these cases. Lawyers inherently are drawn to complexity because it's what worked for us our whole lives. So you're the best in class in undergrad, and a lot of us would be the best in class in law school. And inherently, we like complicated things because when things are super complicated, we succeed where others don't. And we've gotten to this point in our careers where when something's hard and complex, we're naturally drawn to work on that problem. But if you work on the hardest, most complex medical nuance problem, but don't solve the big glaring issue that the defense cares about, you're not helping your client. You're just working in the wrong direction. And when you work in the wrong direction, the reason the defense values your TBI case low is because you haven't added significant risk to them. It's something I talk about in the book of how to build risk and add leverage is you add significant risk to the defense by making the risk of a monster verdict go significantly up, where the defense lawyer's like, yeah, we don't want to try this case. We have crazy exposure here. We should settle it. The biggest verdicts don't come from doing way more work. They come from doing way more work on the right problem. So I'll put it to you bluntly. If you spend hundreds and hundreds of hours working on your case and, quote, working it up, but you're working on the wrong problem, is it really hard work? The most common mistake that I see where other lawyers spend their times when I'm reviewing their file, to give you an idea, we reviewed almost 250 files for lawyers last year. On track this year, we're looking to review 1,000. And we aren't even going to take all those cases. We're going to take 15, maybe total. And the rest of the time, we just help other lawyers work on their cases. And where I see the biggest problem is they'll say things like, what expert should I hire? And they'll use it as not plural, but singular. And then they just send the medical records to the expert and then let the expert interview someone who's got brain injury. And that's it. They don't give them any additional resources to help the expert understand how significant the injury is. And that's a mistake that when you're relying on your client who has memory problems to relay their memory, and that's what you're basing your multi-million-dollar case on, we should rethink that process. I'll give you an example of a case we worked on for a law firm last year that we actually ended up co-counseling it and getting within 2 days of trial before they finally paid the 8 figures that we thought the case was worth. What ended up happening was the lawyer spent hundreds and hundreds of hours working on the orthopedic components of the brain damage case, and understandably so. I mean, they had like 17 fractures, and so they had broken leg, broken ribs, some bruised internal organs, broken wrist. But they spent 95% of their case working on the orthopedic component, and then they had one neurologist. And I was like, you guys, this is backwards. Like, the biggest part of this case is the brain injury component plus the orthopedic injuries. And they're like, we have a neurologist. I'm like, that's not how you work up this case. And they're like, well, how do you work it up? I'm like, well, here. And then I laid out the plan of exactly how we go about working up these TBI cases to kind of get the results we're going to get. Lawyers inherently see TBI cases as another personal injury case, and therefore they're systematically undervaluing them because they're trying to prove their case out of just medical records, which is helpful. You do need medical records to prove a brain injury. However, if I were to tell you a story such as, this is a client who has a memory issue, they have a positive MRI, and the memory component is one of the significant parts of their daily life that's a problem. You think about that. And then I tell a story that is about another client where the client inherently leaves their house, gets lost, has to call someone of their family, can't remember their family's phone numbers, can't figure out exactly what's the best way to be able to get home, and they end up having to have a neighbor walk them back to their house. What case is more significant? Is it the one with all the medical proof, or is it the human story? It's obvious, and those are the same case. And what one do we think lawyers in the traditional approach of working on this case spend all their time working on getting? It's obvious. They spend all their time working on the medical because they see a nail, they have a hammer, that's what they know how to do, that's what they do. When the real value is that second story. If a lawyer spent 80 hours a week for the last couple months working on a case and then they get a lowball offer, what that inherently tells you, it's something I talk about in the book. When the defense gives you a lowball offer, they're saying you haven't created any risk. It's giving you a data point of how risky your firm is to the defense. That's it. Doesn't mean they don't believe you. It doesn't mean they don't believe your client. It just means that they don't really think there's a lot of risk in going to trial against you. And you haven't given them the information that makes them be like, we should talk some more. Like, this is a problem. We need to make this case go away. And until you do that, it's a data point that you should take into consideration that you're working on the wrong problem. I can remember the first time I was working for a lawyer, and I was an intern at the time, and I'd been working hours and hours, and I'd spent like 4 or 5 weeks on the case. The senior partner walked in and made a phone call and made more happen in a 7-minute phone call than I had in 6 weeks. And I remember being like, that's not fair. Like, why can he make one thing happen? And it comes from him taking that 6 minutes with enormous amounts of leverage that actually are working on the right problem, where me spending 6 weeks killing myself working on the wrong problem. They're just not the same thing. Where I may have put in more actual hours, but the lawyer put in more actual hard work to the problem that needed to be solved. Juries don't usually get to see medical records. Some judges allow it, some don't. It kind of depends on the judge you've got. But juries hear the testimony off the witness stand. They hear what witnesses say about the person and how significant the injury is and how significant the brain damage has altered how they're a mother or how they're a friend or how their identity is fundamentally destroyed because they were seen as someone that everyone looked up to and solved problems. And now they're someone that just sits on the couch and has to have people help them. They're fundamentally different stories. To end up talking about persuasion, details of medical records don't persuade people. Stories persuade people, and stories persuade people because of the emotional weight that's conveyed of significance that ends up being able to be translated to the jury that lets the jury know this is someone that needs significant help over their lifetime. The stories are almost compressed ways to show damage of the life that's been destroyed by the TBI, where medical information in a medical record isn't a story. It's just a series of words on paper that the doctor recorded that are snapshots of what they think might be the story. But unless the doctor knows why they wrote down dizziness when they seen 20 patients that day, you're going to have to be able to tell the story some other way to the jury. The client had an 11 millimeter lesion in his brain. We had the proof, we had the MRI, we had basically gold standard evidence of why we should win. But when you have gold standard evidence of why you should win, sometimes you will forget one of the most important pieces, and that's to explain to a jury why money makes a difference. So we had the client, we had the injury, we had the evidence, we had the proof, and then we missed the part where we explain why money solves the problem for him. They came out and the jury told me, we believe your client has a TBI, we believe he should win, but we don't understand why money makes a big difference. And I swore I'd never make that mistake again. And the way I've wrote those notes became one of the principal ideas in the book of why you need to be able to educate the jury before you can persuade. Nobody in the room understood my client and what the brain injury really was. The case settled in the middle of trial, and I think I'd had some massive victory because frankly, the defense paid my demand. They thought we proved our case. They paid the money that we asked for. We all went home. I'm standing out in the hall and the juries are coming out, and the jury listened to the whole trial. And we were within 2 days of the verdict, I think. And the jury, one of the people was standing in the hall, and I remember talking to her, and it was very obvious she was going to be the foreperson. And I said, what do you think of the case? And she's like, you totally proved your client had a brain injury. And I can remember basically like high-fiving myself and be like, yes, I did it. And then the next sentence, basically something I remembered forever. She's like, yeah, you proved the client had a TBI, but I'm not sure money would have really helped. And I remember I was so stunned because I proved the brain injury, but the jury didn't understand how money would have helped. And I'm like, you proved the brain injury, you should be able to get the money for the client. And it was such an obvious thing to me, but wasn't obvious to the jury. I swore I'd never make that same mistake again. And it was the concept that I want all the lawyers to teach. I want all the lawyers to be able to understand it enough to be able to tell the jury, to be able to take care of their clients, that just because your client has a brain injury doesn't mean they understand how money fixes the day-to-day life. Big case, major opportunity. You know it's a monster TBI case and it's coming up for trial. Back when I just started, I had that same situation and I didn't realize the biggest threat to my client and my client's future was me. Let me tell you why. The biggest risk to clients is oftentimes the plaintiff lawyer that doesn't know they're not ready. And I say that because at one point I was that lawyer. It was early on in my career. I'd been past the bar, joined a firm. I've been working for 3-4 months, and there was this big case coming up. And I can remember being like, yeah, I'll lead the trial. I'll go do it. I want to do an opening. And I can remember so clearly the feeling I had and the desire and the overwhelming excitement I had to be involved. And there was a lawyer that I worked with that basically handed me a piece of evidence and said, how do you get this into the jury? I was like, I do this. And he was like, oh, well, what about this objection? And I'd be like, I don't know. And he didn't even have to tell me the follow-on to that, which was, if you don't know how to get that one piece of evidence in, you have absolutely no business leading a big brain injury trial. And it was a big belief shift for me because I viewed I get to be a lawyer. I know the rules of evidence. I did some mock trial. I did some stuff here and there. I'm ready to go take the big shot, do the big case. And it was quite a setback for me egotistically, where I realized I shouldn't be the lawyer in charge. I should be the one that works on the jury instructions and helps with exhibits and coordinates witnesses and sits in the back and isn't the star of the show, because that was the best way I could add value to the client. Where if I inherently, because it was a big case and let my ego get in the way and said, I want to be the star of the show, that is actually the biggest risk to the plaintiff in big TBI cases, is where you have a lawyer that doesn't realize the depth and complexity of a TBI case, all the different traps that the defense neuropsychs or the defense neurologist sets, or where the accident recon is going to try and trip your client up because of what they said in the depo. Not knowing those things is a bigger risk than the lack of medical evidence or the lack of MRI. And the reason for that is there is a problem that's widespread in the injury world dealing with brain injury cases, where people assume a brain injury case is just like any other case. You take the medical records, you interview the client, you hire some experts, you do the case. And it couldn't be further from the truth. And until I had that happen to me, where I learned that sometimes the best role in a case is assisting or co-counsel, or we had a case that just came in 2 weeks ago where we had a giant asbestos case. I think there might've been some firms that are like, yeah, we can do it. It's a big case. We'll figure it out. And there wasn't a question in my mind that, oh no, we're referring that. Why? Is because that's not the best thing for the client. We need to get them to the absolute best asbestos lawyer so that they can take care of it, not us. That's how they get the results they get. It's why we get the results we get on these TBI cases, is we've done them so many times and consulted for so many lawyers and literally wrote the book on it, that's the reason that we've got the reputation we've got, is because we didn't start here. We slowly built up over and over again through all the things that happen at trial, where you learn and you try and figure out what's the best way to put together the playbook that absolutely takes the defense playbook apart. I can remember I was sitting in the conference room and all the lawyers were sitting around in their chairs in this nice conference room table, glass. We're going through all the different cases, and it came up that this case was getting ready to go to trial. And I can remember the excitement in my chest of knowing, like, I'm going to get to go make a difference for someone. And 5 minutes later, the pit I had in my stomach, knowing that I didn't have the skills to make the difference for the client that I thought I did when I'd gone into that meeting. And it was so obvious to me so quickly that the best way to serve the client was not doing the thing that I wanted to do, but doing the thing where I could help the most in the capacity I had at that time. When the lawyer asked me, how would I get this piece of evidence in? And I walked him through how I'd do it. And then he gave me an objection and he said, what would you tell the judge? And I didn't know. He was not telling me I wasn't ready, but he was showing me the problems that were fairly simplistic, that I just didn't have the skill set to solve at that point in my career. And all the lawyers want to be the best trial lawyer immediately. I had a big ego, like anybody. And the thing that I learned was you want to figure out where your skill set is realistically in order to be able to help your client the most. Because if you don't realize what you don't know and the playbooks that you need for TBI cases to get the results you need to take care of your clients forever, it's really on you. And that's what I think I was embarrassed about, is I didn't realize how much I didn't know. And if I would have met the client 5 minutes before I had the conversation versus 5 minutes later after I realized how much I didn't know and what the problems I might run into that I was unable to solve for the client, it was an eye-opening experience for me. And it's one that I help other lawyers throughout the country with their TBI cases, because I don't want them to be in the situation I was in. And mine was dealing with a procedural evidence question, where theirs is dealing with, this is information you can't get anywhere else. The reason I wanted to write the book in the first place was these were all my notes I gathered after expert depots and trials and all these painful things that I went through, that I've read a ton of lawyer books. Any famous one out there I've read. And it was because I couldn't find the tools that I needed that I basically took all my notes and said, I'm going to publish this so that other people can have these tools. What made me decide that I didn't even want to attempt to ask to lead the trial was my ego got displaced by my capability. It's like you can have ego and capability, and sometimes they don't match up. It hurts to have to admit I'm not qualified to do this. But at the same time, pain now versus pain later. If you're not qualified to do something and you think you are, you're setting yourself up for a catastrophic public failure. And the trial lawyers know this again and again. A story I've told before is I once had a defense lawyer tell me, I've never lost a trial. And I can remember telling him, well, then you don't take real risks, because any lawyer that tries a lot of cases, they're going to lose a trial, period. Because trials are the cases that you can't work out ahead of time. They are the ones that have risk on both sides. If there's enough risk on both sides and you try a lot of cases, you're going to have losses. When you realize that you want to bring a specialist in a case, you want to learn as much as you can. It's something that I've worked with co-counsel in some cases that they say, I want to be the best trial lawyer and learn how you try TBI cases. I'm like, great, I'll teach you everything. Like, there's no secrets. The more lawyers that understand how to do these cases at the highest level, the better. It helps clients across the country. If we're just a firm that does cases nationwide, we can't take all the cases. And because we can't take all the cases, the best way to have the biggest impact on all the people with TBIs across the country is help all the lawyers raise the bar, raise their level of skill set of the best way to approach these TBI cases so that we can all do what needs to be done for the clients that have been injured. What would have happened if I led the trial and I didn't realize how much I didn't know about TBI cases? Frankly, we probably would not have gotten a significant verdict, and it would have set him up for a very difficult life for the rest of their life that would have been on me. And thankfully, that didn't happen. I had enough understanding to know that I didn't have enough expertise in an area. Even with trying to bring in the best experts, my expertise and skill set wasn't enough. And so basically I doubled down on working on my skill set over and over and over again until not only I passed the threshold, I got to the apex of thinking, this is the best way. These are the best ways to try these TBI cases, and I have proof to back it up. When I see a young lawyer taking on a really significant case, I want to tell them what I had the painful process of learning, which is you don't have to be the best lawyer immediately. It's always portrayed in Hollywood or Suits or other shows is you get the character and then they do the montage and then they're the best at the thing. The reason they call it the practice of law is you're never at the top highest level. It's always something that you're learning more and more, but you need to get enough experience in that you can speak with conviction, because that's where persuasion comes in. It isn't by some secret trick or magic bullet or one specific trick you do that indicates the outcome. It's thousands and thousands of tiny little nuanced things that you've learned over decades of experience that make the difference. And you learn what works and you learn what doesn't. And pretty soon you can speak with such confidence and conviction because you know it works. You've stacked so much proof that it's undeniable. And that is where you need to get before you can feel comfortable doing the right thing for your client. And when you're early on, you shouldn't be that lawyer. You should pair up with somebody that can teach you those things. You need to find the mentors and the resources that can get you to that level. The faster you realize that you want to stand on the shoulders of giants in front of you, the faster you can start gathering those resources and shorten the time to be the lawyer you want to be. Everybody thinks more cases equal more revenue. When I hear a lawyer that says, I have 100 cases or I have 1,000 cases, I say, how many TBI cases do you have? And they go, only a few. I inherently think they don't know what the cases they have are. Because if there is I had a lawyer just called me 2 days ago. They're like, yeah, I have this collision. It happened at 60 miles an hour. And I said, do you think they have brain injuries? And they're like, no, the CT scan was negative. And inherently I knew you have a closing collision of speed of up to 100 miles an hour. They've got brain injuries. The body was never meant to go that fast. Delta V over a certain amount means inherently there's going to be enough forces to cause axonal shearing and diffuse traumatic brain injury. The brain can't slow down that fast. And so because of it, I think lawyers are systematically looking in the wrong places for their cases. And it's something that if you understand where you should say yes to the brain injury case, it needs to come from a understanding of what makes a brain injury case work. And so lawyers think more cases is more revenue. I don't think that's it. I think it's more cases that need to be looked at and pick the ones you really want to take. For example, I had a case that we said yes to when I was a younger lawyer, 10 years ago. We weren't sure if we were going to take it. We went back and forth on it. And we have something that in the book we call the threshold question, is you can make a case as complicated as you want to. And we do it for when we're going to take a case, and we also do it when we're deciding if we're going to go to trial. You can make something very complicated about, look at all these little nuances, yes or no. But the question really comes down to, are you going to take the case? Yes or no. Are you going to try the case? Yes or no. And everything else is just a emotional expression of something that we're worried about. When we talk about little details that are wrong with our case, I've tried cases where my client has dealt contraband to prisoners. I've tried cases where the lawyer says they are malingering and failed all kinds of validity tests. I've tried cases with significant problems that if you know the right story and if you understand why the frame of the defense about why your client is wrong or not truthful or whatever the issue is the defense is saying is fundamentally incorrect, you can put resources to a case in a way that you can establish what the truth is, because fundamentally, you know the client, you know the person, you know the stories, and the stories are one of the secret weapons to brain injury cases, because defense experts can't make stories medically complex. They can take a CT scan and say, there's no abnormal findings on the CT scan, and try and equate that with no brain injury. Or they can take an MRI scan and say, there's no intracranial bleeding according to this MRI, but it doesn't mean no brain injury. And they try and equate and make things complicated for the jury to misunderstand that you can have a brain injury and a significant one and still have a negative CT scan. It's the same thing when it comes to where you put the resources in your case. With stories, defense experts can't make it complicated. If your client gets locked out of their own house for a code that they've had for 25 years that they've been doing and had no problem up until the incident, and then every day they come home and have to call their wife standing outside their door and say, I can't figure out the code, you don't need a positive MRI to prove that brain injury case. You need the story that the expert can't make complex. And so it all comes back to when lawyers think that they don't have brain injury cases and they have a certain number of cases, I think it's just they have a whole bunch of cases they don't know well enough yet. I can remember calling another lawyer that I knew pretty well, and I sent him a case, and he said, I remember I got the cell phone call, and he called me and said, Taylor. I said, yeah, what's up? And he said, why are you referring me this case? I said, it doesn't fit our criteria. And he's like, what do you mean it doesn't fit our criteria? And I'm like, well, it's not a brain injury case, and it's not worth the level of what our firm takes as brain injury cases. And he said, what do you mean? This is a really good, clear liability, $500,000 case. And I said, yeah, that doesn't fit our criteria. I don't understand it. I said, well, if we're going to be doing a certain type of case, it generally needs to meet the criteria of three things. We call it the threshold question. Are we adding enough value to someone who's had a significant brain injury in a way that fits the way our firm is set up to do these TBI cases? And if it doesn't fit that, we refer it out. Doesn't matter how good the case is. And the lawyer said, I've never heard of any firm doing that before. And I said, it's the way we do it. It's something that we talk about in the book called the threshold question. It's how we evaluate what TBI cases we're going to take and what ones we're going to refer or let another firm work on. Our firm developed the discipline to say no to cases. We have 3 different criteria. If it's a TBI case worth a certain threshold, we'll do it, or we'll help figure out how the other firms should do it. If it's a favor case for friends or family, or if it's a case that we call a case that we should do because we have the resources and expertise to do it. Those are the 3 types of cases we consistently do. And it's a way that we've built our firm to help basically TBI lawyers across the entire country. We can't do every case. And if we can't do every case, the best thing we can do to help all the clients with TBI is give away the expertise that allows other firms to litigate these cases in the best way for their client. I got off the stage at a conference recently. A lawyer came up to me and he handed me my checklist I'd given him, I don't know, a couple months earlier. And I remember seeing all the check marks and he's like, look how good this TBI case is that I had. And I remember looking at my own checklist that he had his client fill out. And then I said, well, and I pointed to one of them, tell me about this symptom. And he said, well, they checked the box. I said, okay, well, what about it? And he said, I don't know. And I said, don't you know what to do next? He's like, no, I thought I just filled this out. And I said, you don't have you have a checklist. You don't have a case. And he said, what do you mean you don't have a case? I said, you don't know the stories that made your client check yes on this. If you don't know those stories, you don't know what your case is really about. And I remember seeing his eyes kind of get bigger and be like, well, what are you talking about? I said, it's something I talk about in the book quite a lot. It's If you have symptoms, each symptom your client has is a story that's not yet told. And what do you mean? The symptoms are exactly them having problem with some part of their life. If they have a balance issue, is it when they get up in the middle of the night and they're trying to use the restroom? Is the balance issue when they get out of the car? Is it when they stand up from a chair? Is it when they walk down the hall? Where's the balance issue showing up? Tell me about if they have vision problems. Is it double vision? Is it blurry vision? Is it they have trouble driving? Is it they shouldn't be driving? What is it? And each one of these, and there's a long list, needs to be understood from the human point of view of like, what is the actual problem that they're going through in daily life that's causing them so many issues? And until you understand that, you don't really understand how to present your case to a jury. You understand how to hand the defense the expert report, but that's the lawyer not really doing anything other than taking a report from one person and handing it to another. You want to give the report your expert gives you and then give it significant emotional weight in human stories and then give that to the defense or the jury. And that's how you take a case from a checklist to what a case should be as you're working it up for trial. Like I discussed in the book, take symptoms, to objective findings, to the stories and the ability to reveal what the truth is to the jury. That's the approach. That's the concept of the book that we talk about called Gather, Focus, Reveal. It defines everything that we do, and it's to get to the truth so that you can compact it, put it into witness testimony, and feel a way to give it to the jury that they feel its significance. When clients fill out a TBI symptom checklist, they don't know what to do next. And that's the difference between lawyers who work on TBI cases and the lawyers who are going to succeed in trying them. Just because you have a checklist doesn't mean you have the case ready. It means you just are starting. The client checked memory problems on the box on the TBI checklist that we provide to other lawyers. It didn't give the depth of the problem. She was a counselor to school. She helped give students advice about their careers and how to deal with their high school problems. And she was phenomenal before she got a brain injury. After she got the brain injury, she quite literally had a coworker sitting 5 feet, 6 feet away from her desk that would write down every single person's name that visited her that day and show her at the end of the day because she wouldn't remember. It's someone who wanted to keep her job, wanted to have the fulfillment identity of helping these high school kids. The coworker who we found took us a bit to find her because we said, where's the memory problems really a thing? And she didn't have a husband. And she was talking about how, she was struggling at school. And we tracked down the person who sat outside her office at the school. And that person, we got on the phone and she said, it's the most devastating story I've ever seen. I used to caretake for my mom who had dementia, and this is worse. And you hear a story like that, you realize the significance of someone who needs help for the rest of their life. I view it as a law firm has 3 different stages of working on TBI cases. The first is they don't have a TBI checklist. The second is they do have a TBI checklist, and after the client checks memory problems, they take the checklist, scan it or put it electronically in the file box and stick it in a drawer, and that's the end of it. And the third is the ones that follow the systems in the book of knowing exactly how to take a symptom, get the testing, and figure out exactly how to present that type of story to a jury. That's the level you want to get to. The difference between a client checking something on the TBI symptom checklist and a client being able to tell a story, or a coworker or a family member being able to tell the story, is quite literally the difference between an offer of $500,000 and a couple $1 million verdict. One story. It's that big of a deal. If I could only ask the client one question after I get their TBI symptom checklist, it's something I talk about in the book. It's whether or not they've had anything strange happen to them. And this is a pretty big framework that I want everybody to understand. If you ask somebody, tell me about your brain damage symptoms, they don't know what those are. They don't understand that memory problems could be it, or talking slow could be it, or any of a number of things could be symptoms of a brain injury. Where you ask, what's been strange for you since the incident? All of a sudden, they will overwhelm you with stories of weird things that are happening and, frankly, strange things to them that are often signs and symptoms of a brain injury that they don't understand that's what it is, but it ends up being the best stories that you can then tie to the symptoms that the experts need. When you do traditional intake for somebody who suffered a TBI, there isn't enough time to gather enough information about the client. Because if you do the standard approach of if it's an ortho case or a TBI case and you do intake the exact same way, you don't have enough information about your TBI client. There's so much information that you need to gather about their day-to-day life, what's changed, what's strange, what's weird, why are they having difficulties with certain things that they never had problems with before. And it's silly things. It'll be the toaster or an alarm clock, or they can't turn on certain lights that just seem so odd to them, but tell you they have problems with sound, or they have problems with photophobia, or they have problems where they go to movie theaters and bring dark glasses. Things that they think is strange are some of the best evidence for what the symptoms are as a result of their brain injury.
This book has been 7 years in the making. For more information on how to get your copy, I added a link below. Let's raise the bar together. I'm Taylor Ernst. Thanks for watching.